Hello, this is John Milburn, providing commentary in relation to Jerry Bates' Chapter 6. Chapter 6 deals with environmental legislation, the purpose and structure and content of that legislation. So what we're considering here in this chapter is how does environmental policy translate into law, which is the parliamentary side of the separation of powers. How do regulators then become empowered and instructed to implement that policy and through directions and initiatives, and that's the executive part of the separation of powers. The scope of the law falls into that category which is essentially public law, and legislation creates the ability for administrators to implement and enforce that law. But only specific legislation can create and authorise regulatory bodies to implement and enforce law. In other words, the executive branch of government has no inherent power to do anything. It must rely upon the power that is conferred upon it. The third part to the separation of powers, of course, is the courts. And the courts have the power to interpret the statutes and make sure that the regulators act in accordance with the boundaries of the legal authority which had been set by Parliament in relation to their abilities. Now, the decisions of regulators at administrative level may sometimes be tested through appeal in the courts based on the merit of the decision making. This is very important in environmental law because courts and to some degree tribunals have power to essentially make a decision correctly and preferably in circumstances where the administrators did not. So the question is partly, have the administrators acted lawfully? But more often, it's a merits review, which is a question of determining whether the appropriate decision was made in circumstances where there was legal authority to make that decision. Clearly, the legislation which is passed is designed in many ways to protect the social values which are enshrined in society and give lawful effect to the policies of government. And those policies generally come about as a result of our overall system of capitalism, but also the way in which federal governments have implemented and seek to implement international law, which, as we recall from previous discussions, can only become effective at a domestic level once it has been passed as domestic law. We talked about what essentially environmental law does, and that is to restrict and to some degree place conditions upon the way in which private landowners use natural resources or public resources. In other words, the environmental legislation is designed to ensure that the public good is always considered when there are private concerns using these public resources. Bates makes reference to the National Competition Policy. Now, that policy was implemented with the express purpose of ensuring that there is economic efficiency by removing regulatory impediments to productivity. So in many ways, environmental law is seen as acting inconsistently with the way in which national competition policy is implemented. In other words, rather than free the market to determine what it should do itself, the question of environmental law is to provide those restrictions which are deemed necessary. One way that that's being done is by providing initiatives or incentives to ensure that there is good product stewardship by the producers of products to ensure that environmental issues are considered even after the product has been used. So manufacturers now are encouraged to take responsibility for the way in which products are reused or recycled or disposed of when those products have become no longer useful to consumers. So part of environmental law is to structure the initiatives and the incentives and outline the guidelines to ensure that that is done. So when we talk about the structure of environmental legislation, Bates says we need to consider 4 parts: definitions in environmental law, the way in which different legislative regimes may apply to the same activity, the objects of the legislation, and also the statutory functions. So let's talk about the definitions. Now, the golden rule in interpreting a word or a phrase, perhaps in environmental legislation, is to first check whether the statute defines the term. You'll see most often that there are dictionaries contained in legislation. So that rule in environmental law is no different to the rule in interpreting legislation generally. But if it does not, then the second thing to consider is whether the term is intended to bear its ordinary everyday meaning or whether there was a specialist meaning intended. The courts have said that the grammatical or natural interpretation may be abandoned only in circumstances where it is clear that the legislative intent was that it should have a more specialised meaning. So that's why it is important sometimes to consider the documents in Hansard, which provide the preliminary documentation prepared prior to introduction of the legislation. So in the absence of a definition, a grammatical or literal approach may be used as the starting point, but that can be abandoned if it's clear that the legislation was intended to do something more specific or more specialised in terms of the wording. If a term is ambiguous, then the Acts Interpretation Act may be considered to provide some guidance as to what is meant as well. Right, so that's the first part of interpreting statutes, environmental law. The second issue raised by Bates is that different legislative regimes may apply to the same activity. So in law, there is no inherent conflict in having a number of pieces of legislation apply to the same activity. But there are questions, of course, that must be raised as a result of that, where you have a number of statutory interpretations intending to operate in relation to the same activity. If you have conflicting laws, that can obviously lead to problems where there are provisions for conservation or protection conflicting with the provision allowing for damage or destruction in certain circumstances. So general powers, for example, to remove vegetation could be construed by specific powers to protect as opposed to the more general power to use or utilise the property. Where there is a conflict which is perhaps irreconcilable between legislation, then the courts have to determine the hierarchy of provisions. Now, in that context, it is clear that a Commonwealth law will override a state law. Also, it's clear that a later statutory provision must be intended to have overridden an earlier one. And finally, where you have something which is an express power, that must be intended to have priority over something which is a general provision. The third aspect that is discussed by Bates is the question of the objects of the legislation. I mentioned before that you may have, from time to time, recourse to the Acts Interpretation Acts, and that's throughout Australia. So that will provide some guide as to the way in which legislation should be construed or constructed, as we say. In the Blue Mountains Conservation Society against the Director General, National Parks and Wildlife Service from 2004, referred to in Bates, I have some difficulties with the decision. A ministerial approval for filming within a wilderness area was held to be invalid because the approval did not promote any management purpose or objective of park management. Indeed, by excluding the public, the court held that while the filming was in progress, an objective of the park was denied. The reason I have some concerns about that decision is that I would have thought that promoting the beauty of the park through the film might have been a valid and appropriate purpose to be fulfilled in accordance with the legislation. Now, Bates goes on to say that essentially the precise words which are used in legislation can be quite important. So do look out for that when considering the way in which legislation is interpreted. So if there are instructions to administrators through legislation by words such as seek to further or pursue or give effect to or achieve objectives, they may be regarded as imposing stricter or more focused duties than mere instructions to have regard to those objectives. That can have a bearing on the way in which cases are decided, because it may be that courts will decide that administrative bodies have given too much thought or considered too heavily certain matters, or may not have considered those matters seriously enough. So in Rosemount Estates against the Minister for Urban Affairs and Planning, a 1996 decision, the Court of Appeal held that the inclusion in an act of a specific power that enabled the minister to effectively override the general object of public participation was considered. So that's an example of a case that you might look at. Now, the fourth area, which is discussed by Bates in the context of statutory interpretation and its purpose, is statutory functions. And statutory functions may be regarded as either mandatory or directory, which is discretionary. Statutory duties are commonly used or are commonly talked about in terms of the context of an authority must or shall, which will require an obligation, as opposed to the discretionary words such as may. So be mindful of whether the statutory function is mandatory or merely discretionary, depending on whether words such as shall or may are used in those circumstances. Now, decision-making under statutory schemes is subject to principles of judicial review, and that's to determine whether the duties or powers have been exercised in a way which conforms with the legal standards for decision-making. Now, the criteria for decision-making may be of general application, or it may be specifically drawn for a particular purpose within a statutory scheme. One of the most common criteria for decision-making in that regard is to consider the principle of ecologically sustainable development, and you'll see that referred to very often during the course of environmental law. But it is common for legislation to require decision makers to apply specific criteria in relation to certain things, certain powers, such as the allocation of rights. And we talked about that previously. Now, an important purpose of legislative schemes for environmental management is to confer powers on regulatory authorities to create and use a wide range of tools relevant to the particular context or situation. Some of those tools may be mandated through legislation. It may be that there is an option to use them, depending on the wording that's used. Important in that context is the whole question of evaluation and licensing. So it's common in natural resource management and in legislation dealing with the protection of the environment to allow for administrative bodies, competent authorities, to permit certain activities by license that would otherwise be unlawful. And Bates quite rightly makes the point that licensing is essentially the backbone of environmental law. So at an administrative or executive level, certain people are entitled through licensing to develop land or emit pollution or take native or endangered wildlife. But as a matter of law, conditions of licence must be imposed, and if imposed, must be fairly and reasonably relating to the permitted activity. They must be certain, and there must be some form of assessment of the environmental impact which might be made. When it comes to the way in which environmental law as it is administered, environmental assessment is almost always required. Now, a statutory licence is a legal agreement between the person who's entitled to use a resource and the statutory authority which is empowered to control the process or to regulate the particular activity. We talked previously about the nature of property, and we did so in the context of when property is taken from someone, are they entitled to compensation? Now, people who receive the benefit of licenses through statutory authorities often view their entitlement under a license as conferring on them something which is akin to a property right. The question is whether they receive property rights or merely a permissive interest. So a person, for example, who has the right to license, has a licensing right to commercial quantities of fishing, may regard their entitlement as being something which can be traded on the open market and not necessarily attached to a particular person or a particular boat. The return to some form of private ownership of public resources is argued as having the potential to give incentives to exploiters of natural resources to take more responsibility. Modern environmental legislation focuses more on the complementary regulatory approach, which provides essentially a sticks and carrots approach, that is, penalising certain behaviours but providing carrots for better performance. So in conclusion, in dealing with Chapter 6, ultimately Bates has been discussing the way in which beneficial environmental results can be harnessed through legislation and the decisions of the executives by licensing and by the proper administration of the executive part of government. Thank you for listening.